Good evening, everyone. Tonight being the very last night that you have to write your exams, I thought that we should meet to encourage you and also to address any issues that may be bothering you. So, of course, we can understand the situation in which you are. You need not be anxious because you've done enough reading before tonight and certainly before tomorrow's exams. So just relax, and all the pieces of advice that we'll be giving you, just take them seriously. So that you'll be able to do good work tomorrow. So having said that, I would be happy to address maybe issues, concerns that may be bothering you. So if you have any, but just make sure that only one person is speaking at a time so that we can have a very well-organized interaction. So feel free to speak. Okay, so I presume that there's nothing for you to present for us to discuss. So I may have to go. You can also use the chat. If your mic is not helping you, you can use the chat to bring up your concerns so that we look at them. So just before anybody brings up anything, let me emphasize what I've said before, that don't forget you are still at the LLB level, so you need not be unnecessarily worried. So you are still LLB graduates, so get that. You're not LLM students, you're not a PhD students. And for that matter, any question that you get from any of the 6 examinable areas, be it constitutional law, be it contract, criminal law, land law, tort, organ legal system, the same way that you have answered it if you were sitting an LLB exams is how you should go about it. So you don't need to panic. But then, as we have told you time and time again, that if you have a problem-based question, please, we're in the common law jurisdiction, okay? Or even the civil law jurisdiction, to a large extent, the same approach. They use the IRAC. You identify your area and then you raise issues, the legal questions. And then you take each issue, state the principles, and then you do the analysis and application and try to demonstrate whether the principles that you have stated are actually satisfied in terms of the facts that you have in the passage. And then you conclude on that, then you move on to another issue. So you repeat that until you are done, and then you draw one big conclusion, okay? So keep that in mind. And then, again, if you have your essay questions, as we've said, be structured and organize your points well. I think there's something in the chat. Let me look at this in the chat, and then if you are not speaking. So somebody is saying that, can we, how are damages assessed when there is a death in relation to tort? Yeah, okay, so somebody wants to know how damages is assessed when there is a death in relation to tort. I think in our 2 or 3 previous sessions, or I don't remember, but one of our sessions, we discussed this, and then we actually we went to the extent of looking at the Civil Liability Act, okay? And we said that what the Civil Liability Act seeks to do, among other things, is to try and preserve causes of action which were vested in a person before he died, or if the person has not died, what you could have actually litigated. So that is saved by the Civil Liability Act. And then in terms of damages, like compensation award, where a person has died, if you look at the act, you notice that it's about dependents, right? Dependents, and we have like the range there. Spouses or wife and children and so on and so forth. So that is how it is done. So if you haven't looked at the Civil Liability Act and you think that you need to know how damages are assessed, where you are dealing with a case like a tort case where a person died, and let's say that his personal representatives have actually sued in respect of the death as a result of someone's tortious conduct, then you must look at the Civil Liability Act. Okay, all right. Then another person has asked a question. Can we briefly go through mistake and vitiating factors? Okay, so vitiating factors, we are dealing with the law of contracts. And vitiating factors, as we have learned already, refer to those matters which, when present, affect validity of the contract. Affect the validity of the contract in the sense that consent of a party or of the parties are said not to have been properly be given or exchanged. And this may come about in many ways because one person or both parties entered into the mistake as a result, the contract as a result of a mistake. And then where the contract was entered into as a result of mistake, what that means is that one person had a fundamental misunderstanding about the facts relating to the contract, so that if it had not been for that misapprehension of that particular fact, he wouldn't have given his or her consent to that transaction. So let's keep that in mind. And we know that at common law and equity, mistake manifests in 3 ways. We have the the common mistake, we have the mutual mistake, and then we have the unilateral mistake. So maybe let me start with the unilateral mistake. Unilateral mistake is where, just from the word one, where only one party has actually made a mistake, and then the other party with whom he apparently contracted is very much aware that the other is mistaken. So contract between A and B, A enters in the contract with B thinking that he's actually contracting with, let's say, C. B is very much aware that A does not intend to contract with him. A intends to contract with somebody else, C. But A is not aware that B has interposed himself between A and C, so that A ends up not contracting with B, and not contracting with C, but contracting with what? B, unbeknown to A. He thinking that he's actually contracting with C, when he, as a matter of fact, is contracting with what? With B. So that is a unilateral mistake as to identity of the other contracting party. So where you have that scenario, the law has a very cautious approach. The position of the law, as you know, is that you are presumed to have intended to contract with the person that you actually contracted with. So there's a presumption that you intended to contract with the one that you actually contracted with. However, this presumption may be rebutted or may be displaced in appropriate set of circumstances. And for that reason, the law creates two scenarios where the parties contracted face-to-face, what we call inter partes contracts, and then where the parties did not contract face-to-face, but they contracted remotely, what we call contract in absentis. So it is the law that where the parties appeared, in front of each other and had the transaction or the contract, then they are presumed to have intended to contract with the person who was physically before him or her. So that is the presumption. And for that matter, in contract presentis, it is more difficult for the presumption of you having intended to contract with the person that you contracted with to be displaced or to be rebutted. So that is one thing that we have to remember. And again, where the parties contracted, let's say remotely, it is relatively easier to displace the presumption that a person did not really intend to contract with the other party that he or she ended up contracting with. So let us keep that in mind. And if we look at the authorities, it may well be that maybe you have a right of set off against someone that you intended to contract with, and not the one that you actually contracted with, and so on and so forth, as you can see. But in all cases, how they actually play out is that the item which was actually exchanged under the contract vitiated by or affected by the unilateral contract is usually, of course, the person who get the item is called like a rogue or like the fraudster. So this rogue or the fraudster will get the item, and this contract, which was concluded as a result of his own fraud, that is the unilateral mistake which the other party had made. Now he takes the items away, he goes and sell it to a third party, and he will get value from the third party, and then he may disappear into oblivion or somewhere you cannot be located. Now later on, the party who made the unilateral mistake, and for that matter, had this item or article taken away by this rogue or this fraudster, he will come across his item or his article in the hands of a third party, someone that he has never dealt with, and he may want to recover it. So it either goes to the police or some other means, or he you just sue the person who is having the item in a tort of conversion, right? That you've taken my property to deprive me of my ownership without my permission and so on. So you sue. But before the court can determine whether the property should be recovered from this third party and restored to the original party who entered the contract as a result of unilateral mistake, the court will need to find out the title, that is the status of title or ownership, which the rogue or the fraudster, that is B, obtained from the original party, that is A. Now, if the court makes a finding that the rogue, that is B, obtained a good title from A, and for that matter, at the time that B was dealing with the third party, he had a good title, then the third party will get a good title, and A cannot recover it. On the other hand, if the court comes to the conclusion that when A, the mistaken party, that is the party who had actually been the victim of unilateral mistake, became aware of the fraud, he took steps to actually have the contract rescinded. That is, to consider the contract as not really binding upon him and so on. He did some open or overt act to show that he has actually rescinded the contract. What that means is that if B, that is a rogue, goes to dispose of the item he acquired from A under the contract vitiated by unilateral mistake, he will not be able to pass a good title to the third party, that is C. And for that matter, if the original party, that is A, subsequently sues the third party in a total conversion to have the item recovered, the court is more likely to agree with him because the contract between him and the rogue was a voidable contract, and he had actually avoided it before the rogue was able to dispose of the article to the third party. Yeah, so that is how the court will deal with the unilateral mistake. You know all the cases, the word Lewis and Ivory, Phillips and Brooks, Ingram and Little, Sugar Finance, and all that. So I'm sure, you've read this enough, so we won't go into that. We have a very limited time. Then, with respect to mutual mistake is where both parties to the contract have made mistake in entering into the contract. However, the mistakes that they have made are different in the sense that the offeror makes the offer with a certain understanding. However, the offeree also accepts it with a different understanding. And for that matter, if we are going by the principle of law that in a contract, there should be the meeting of minds, there should be consensus addendum. That consensus addendum will be lacking in a mutual mistake because the parties are said to be at cross purposes. Their minds do not meet. And you remember the well-known case of the Raffles and the Witcher House, where someone enter the contract saying that, yes, I have goods in a ship sailing in October, and I think the purchaser also accepted to buy goods from ship, which will sail in December. So the minds of the parties, if you like, did not meet. But mind you, we are not talking about the subjective mind. We are talking about the objective test. And for that matter, where there's a mutual mistake, it does not automatically render the contract void, right? What the court will usually do is to apply the objective test and find out if you use the official's bystander position, can we say that the two parties never agreed on anything? If the court can find an apparent agreement, that is, going by the objective test, if the court can find that, yes, a disinterested third party, official bystander, looking at what the parties said to each other or what they did, would understand the parties who have actually agreed on a certain thing, then despite the fact that in the individual minds of each of the parties, maybe they are thinking differently, the court will still infer the presence of agreement, and for that matter, give effect to it. And the court will not say that the contract is actually vitiated by what? A mutual mistake. No. But where the court applies the objective test, and then the court is not able to find any apparent agreement, then there is no a valid contract, as it were. And again, we also have what we call the common mistake. So common mistake, as the name suggests, means that, yes, both parties have made a mistake, and then the mistake that they have made are the same. That is to say that they all had the same misunderstanding or misapprehension regarding a fact relating to the contract. So, and you remember where cases like the Cooper in the fifth and so on, where someone enters into contract to rent, let's say, a property, which he thinks does not belong to him. And then the other party also, let's say that they rent it out to him, thinking that it doesn't belong to the other party. And let's suppose that the facts actually later is discovered that maybe as a result of some inheritance, the one who actually came to rent the property was already owner. And for that matter, he needed not to have actually even rented that which belongs to him. So here, both parties have made a mistake. And for that, the contract is vitiated. I haven't seen any other questions, so I presume that there's nothing more for us to discuss, but you can also speak. If you have anything, you just unmute yourself and speak, but make sure that only one person is talking at a time so that we have some kind of order. On the other hand, if you don't have any issues, so you can go to bed and rest enough so that you'll be well refreshed for tomorrow. Okay, somebody has brought a question that unborn child to a woman who is unmarried is subsequently born alive. What would be the time within which unborn child to a woman who is unmarried is subsequently born alive? What would be the time within which Oh, okay, it's gone. The person taking it away. Please use the mic, okay? You can use the mic. Good evening, everyone. Tonight being the the very last night that you have to write your exams, I thought that we should meet to encourage you and also to. Sorry, I think there's a playback from the issues that may be bothering you. So, of course, we can understand. I think there's a problem. What do you hear? I hear the playback of what we have said already. Is it the same at your end? Can anybody confirm?
Yes, it is.
Yes.
Yes, sir.
What are you hearing?
Be giving you, just take them seriously.
Is it
The beginning of a lecture.
Yes. Yeah, I find that strange. Why?
Tomorrow.
Because we are streaming on the YouTube. I don't know. Let me see.
Be happy to address maybe issues, concerns that may be bothering.
So maybe what I'm going to do to solve this problem, I'm going to end it and then I will start all over again, so that
we can have a very
unless someone has a solution,
organized interaction. So feel free to speak.
Or let me stop the YouTube live and then I will. So can you hear me now?
Yes, sir.
Yes, sir.
Oh, okay.
Yes, sir.
Right. See the chat.
Okay, so I presume that
Why?
there's nothing for you to present.
Somebody is playing. Somebody is playing the recording back end. Okay, so if you have any issue, just unmute yourself and then just speak. Okay.
You can also use the chat. If your mic is not helping you, you can use the chat to bring up your concerns so that we look at them. So just before anybody brings up anything, let me emphasize what I've said